Well, we want to welcome back to the studio Stan Pierchoski. It is time for Pierchoski Estate Law and Bulletproof Estate Planning. Hey, buddy.
Good morning. Good morning. It is time for that.
Yes.
It's every Friday morning. We were out last Friday because we were celebrating the 4th.
Yeah, and you had family coming in?
I did. About a week ago Tuesday they arrived, and so I've got 3 young grandchildren.
Yeah.
One 5, one 3, and one month old.
I was going to say, you got a brand new one.
My daughter and her husband. And so we got a house full, and it's getting. I'm getting used to it. My wife and goes from my wife and I there to that. So
You went from a house of 2 to a house of 5.
You know what?
No more than that.
On Friday mornings, I take the trash out to the end of the driveway for the guy to come pick up, and usually I take it out. There's one bag in there too.
Yeah.
Right? It's kind of I go to get the trash, and the lid won't close.
Oh my gosh!
It's good. And it's full of diapers too. Have those things get?
No.
Oh my gosh! But anyway, it's family. It's fun. Tammy's in grandma heaven. So.
Oh yeah, absolutely,
absolutely. She's helping out a lot. So. All right, so we are here again on Friday morning for Bulletproof Estate Planning, and this is a show we talk about estate planning, all kind of things.
Sure.
It's a call-in show, so let's go ahead, because we always forget to give the number, but let's give it.
Let's do.
That number is 766-9393. Pretty easy one to remember.
Yes.
766-9393. If you have a question, or certainly if you have an experience that may lead to a question, we'd certainly entertain that sort of thing. So, I want to tell you about the next seminar coming up.
Oh yeah.
It's going to be 2 weeks from tomorrow, which is July 25th. That's going to be right here at the WLX radio station in the back of the building. It's a Saturday seminar, so we always do Saturday seminars at 10 o'clock in the morning. And we call it Wills, Trusts, and the Nursing Home. And that's what we're going to talk about. We usually try to start as close to 10 as we can. It's about an hour and 15-minute length presentation. And we have a pretty involved Q&A at the end of it. The last one I did was at the Star Theater back in May. That was I think that was one of the longest question and answer periods I entertained. It was probably a good hour to an hour and a half, 15 minutes or so after the seminar.
Yeah.
Answering questions. And I'm happy to do it. Don't leave. If you come to a seminar and you have a question you bring with you, that's great. Or if you develop one during the seminar,
yeah,
that's great. But don't leave with a question unanswered.
Sure.
I'm more than happy. I offer the time freely, and I'm not. I don't mind. So
yeah, absolutely. Absolutely. Well, it's a great benefit, and it gives good information, and then and helps people maybe plan what they need to do. Absolutely.
And in this political environment, it's not a bad idea to protect your stuff.
Absolutely. And we've got lots of people wanting to take our stuff.
That's right. That's right. We were talking off mic a little bit. And of course, we don't like to get political on this show or any show.
But I do.
Well, that's okay. You do. Well, I like to. I just don't.
Well, you have to be careful. You don't want to hurt anybody's feelings.
I wanted to tell a real quick story that I've always remembered, because when you and I grew up, I'm a little older than you, and we grew up in the heavy Vietnam area, and
sure.
I was late in the Korean conflict, and
yep.
All those wars that we fought like that were to stop the spread of communism.
Absolutely.
And actually, to be a communist in the United States, they went after you.
Yeah.
The McCartney hearings and all that, they would put people in jail for that. And I remember reading something one time that was talking about kind of what communism was, because I was young at the time.
Yeah.
I was, during the Vietnam era, I was, just coming into my teens. Okay. Of course,
Sure.
the Vietnam thing went on for a long time, so
it did.
I started with my teens. Anyway, there is a story that a description of what the concept of communism is. Because when you look and see what's going on today, you see they offer a lot of free stuff.
Yeah.
And it's like, okay, there's no such thing as a free lunch, right? I mean, if you've got free stuff, the bill's coming due somewhere. And so that's usually what makes the system fail.
Sure.
But the story was this. This guy, he goes out into the wilderness and builds a house. He wants to have horses, but there's wild horses around, but he can't catch wild horses, pretty hard.
Yeah.
So he goes out and he clears off a little field, clears it off, and he puts some hay out in a pile, and he does it every day for a few days, and sooner or later he sees a horse or two out there, and of course when they see him they run off. So, but he does it every day, and then he goes out there and he sticks a post in the ground, and the next day a couple of horses are there, and next day or two he goes out and puts a second post in the ground, and I'll speed the story up.
Yeah.
And he's putting his posts in the ground, but he's feeding every day, and he's putting the posts kind of in a circle.
Yep.
8 feet apart or something.
Yeah.
Like that. So very slowly. And he says, I started to notice that the very old and the very young would come first and eat the hay. So the middle-aged ones, the stout ones, were a little more reluctant to do that.
Right.
And so, and the story, you can tell the story as long as you want, where he slowly puts the poles up, put a bottom rail up, a little bit at a time.
Yep.
More and more horses come to feed, and as they get used to him being there, and every time they show up to eat some more hay, what he's doing just changed a tiny little bit. He put up another rail.
Right.
Or something like that. Anyway, he gets to the point where he's got 3 rails all the way around, and finally, he's got this one open spot, and they still go in to get because they're pretty used to it. And he said, put a gate up on there, and he said, just one day I just closed the gate.
Yep.
And that's a good example to remember.
It is.
It's so attractive to go for the free lunch,
Yep.
so to speak, which there is no such thing. But anyway, and then by the time you realize what happened, it's too late.
Yep.
You're thoroughly ingrained in it. And I just thought it was a good analogy, and I'm going to get off any political soapbox at this point. But that was an analogy that stuck with me because when I was a kid, that was this communism, anti-communism was always all over the news.
Yeah.
People were in Vietnam stopping the spread because it was trying to go from North Vietnam to South Vietnam. Right?
Yeah.
And anyway, same thing in Korea. So
Just last night, we didn't do it, but we started to watch the animated movie Animal Farm, which is based on the book Animal Farm.
Oh, okay.
Yeah. You're familiar with that, I guess.
Vaguely. I think I am.
It's basically about communism and
okay.
what happens. So anyway, we didn't end up watching it, but I have seen that, and of course the book was it.
I was just saying, there used to be these greeting cards that were animal related.
Yes.
It had a name like that, Animal Farm or something like that.
Yeah.
And on the back they had a slogan that said, Animal Farm, where some animals are more equal than others.
That's right.
Do you remember that?
That's right.
Or something along those lines.
That's right. Well, in the story of Animal Farm, of course, the pigs end up taking over,
Oh, okay.
and they end up being the bosses,
Okay.
and just rule everybody and everything.
Well, sounds like a version of Planet of the Apes, right? Oh well. But anyway, we won't get off. We won't go down that.
We didn't go too far.
We don't go down that rabbit hole.
Too far, but of course we are here to talk estate planning, and the phone lines are open 766-9393, and don't forget that seminar July 25th.
Yeah,
Put it on your calendar. And it's free.
It is. I don't charge anything, and also don't pressure you.
Yeah.
Every now and then I get somebody they'll call and say, or they'll call for somebody, like somebody that wants to come see it and have a secretary call.
Yeah.
And they'll say, okay, what's the catch? No lawyer's going to give up 2 hours of his time for not getting paid.
Yeah.
And I chuckle sometimes, and I say, no, that's exactly what I do. And I like to fire back with, well, tell your boss I'll even have some food there for him. We'll have some refreshments for him. So I mean, I don't charge it. It's called a free educational seminar. I kind of harp on the word educational, but it's at no cost. And the reason it might be worth something to talk about how I got started doing these seminars.
Yeah. How did you get started?
Well, I like I said, I used to do criminal defense work. I did that for about 10 years. And again, practice of law is a second career for me. I spent 20 years as an engineer in the nuclear power business, and I decided to go to law school, and I went to the Nashville School of Law, which was actually a night program.
Yeah.
And I did. And I started practicing in 2002.
Okay.
And I'm still an engineer. I just don't do that as a job anymore. But I'm engineering stuff at home all the time.
Yeah, I got you.
But anyway, and in the first 10 years of doing that, I got into the criminal defense work. And I was a trial attorney. Did a lot of trials and stuff like that.
Yeah.
But anyway, this was a second career for me. So, and somewhere around 2013 or 14, I just had this internal feeling. I like to say I wasn't burnt out. I wasn't sick of it. I wasn't just tired of doing it. I just had this internal motivation to change. It's hard to explain.
Yeah.
Sometimes I refer to it as divinely inspired. Because it's one of those things that happened, and the feeling was so strong, it was just like I was being told, just do this.
Yeah.
I don't hear voices. I'm saying I couldn't turn away from it. I constantly was thinking about doing it. I constantly looked into it, and then I just started. When I decided to go down this path of estate planning, I just weaned off the criminal law because there, you got cases in there. You got to have them for a little while before they're finished, and I just didn't take on anymore. I told the courts not to appoint me anymore. I didn't really want it, and so it took about 6 months to a year for the cases to clean up, because I did a lot of, because I was a trial attorney, I did a lot of like homicide and murder cases, and those things take a long time.
Yeah.
But we cleaned all those up, and then I just never took anything new on. Anyway, so I started doing the estate planning, and as I got educated in estate planning, so we talked about estate planning in law school, but not much. So there's a lot of self-education involved.
Sure.
And so, you know, there was a lot of resources available to me to learn all about it. And one of the things I learned early on was there's a lot of options when you do that. Me, like everybody else, like I said, when I had estate planning in law school, it was, what's the word? We used to call it a gee-dunk course. I mean, it was like, you know, falling off a log. You know, you got an A if you just showed up. And
Yeah.
They didn't talk about much, but you know, they talked very briefly about some of the stuff that I do.
Sure.
And so, you know, I was like everybody else. I knew there was things called trust, and you know, sometimes you hear them out in court where somebody's suing somebody and somebody has a loss. They create a constructive trust, and it's just a way to make somebody whole. But I mean, I knew there was trust, but I wouldn't really quite get the concept of them in estate planning. So
Sure.
I started looking into it because that's a big part of estate planning, and I learned all about it. And then I would talk to people that would come in, and they'd come in and say things like, "This is something I heard a lot." They say, "I'd like to make a will. My wife and I want to do a will."
Yeah.
And I would say something like, "Great, I would be glad to do that. Would you like to hear about other options?" And almost 100% of the people would say, "I didn't know there was another option. I just thought a will was all I could do."
Right. Right.
And that whole concept, I won't belabor it, but I mean, I got a lot of that kind of feedback, and I would spend time talking about what the trusts do and the different kinds of trusts and so on. And almost 100% of the time, people said, "Well, I never heard that before, but that's definitely a better fit for me than a will." You know,
Yeah.
that sort of thing. And that's what spawned the concept of the seminars. And I just thought I tried doing that one of these days, and I did it. Was in my office over in the square in Pulaski there, and the theater was nearby, and I was involved in the theater. So you know, I talked to them if I could rent it for. I think we used to do them like on Thursday night or something like that. So we had seminars, and of course, in the very beginning, they were attended, but not very well. I mean, I was brand new at marketing. You know, I never, you know, when I was doing criminal defense work, my idea of marketing was to take an ad out in the phone book.
Yeah.
That was back when we still used phone book, right?
Phone books, yeah.
So I took it on the phone, but I didn't do much anything else. I mean, every now and then somebody would walk in and the county fair was going on. They said, you know, give us $100 and we'll put your logo somewhere, something like that. But
Yeah.
I never did any kind of marketing, so I wasn't sure how to let people know I did this.
Sure.
So I started these seminars. And as we started them, we started learning some lessons. Like we used to do them on Thursday night, and we would do like 2 of them in a night. We'd do one at like, if I remember, we'd do something like 1 at 4 o'clock in the afternoon and 1 at 6. Kind of thinking that, well, the 1 at 4 o'clock some people come to, but the 1 at 6 gives other people time to get home, feed the kids or something, and come.
Sure.
That sort of thing. So, and we did that for a year or two, and it became slowly better attended. But then we did that for a long time, and then we started just doing one of them that evening later on, the 6 o'clock, because first of all, it wore me out doing 2 in the night.
Sure.
And sometimes we did them for a while. If I remember right, we did like 1 at 6 o'clock on Thursday and 1 at 6 o'clock on Friday, or something like that.
Sure.
Split
Sure.
it over 2 days. And so, anyway, we just experimented with stuff, and some things worked better than others, and on and on. And so anyway, I don't know, I think just about 3 or 4 years ago, 5 years ago, we started getting requests from people about doing them on Saturday. Now, I thought about doing them on Saturday, but I thought, you know, nobody's going to come on a Saturday.
Yeah.
But you know, we started getting requests from people that said, you know, I get home from work and I can't come to the seminar, or you're having it at 4 o'clock, I don't get off till then. You know, most people are earning a living, right?
Right.
And we got a lot of requests. Can you do one on a weekend? And of course, Sunday would pretty much be out. But so we thought about it and we looked into it. And we thought, you know, let's give it a try and see how it was, because it was pretty much by popular demand to do one.
Yeah.
And so we did it, and it turned out to be pretty well attended. And we still did those ones on Thursday night for a while. We would kind of like back and forth and back and forth.
Sure.
And the more we did it, the more people just preferred the Saturday thing.
Yeah.
And somehow we honed in on the 10 o'clock in the morning thing. I kind of looked at it like, you know, I look forward to my weekends, I like to get things done. So if it's not smack in the middle of the day,
Sure.
you know, like sometimes you have to go to a wedding. It's right smack in the middle of your Saturday. It's
Yeah.
like, you know what, it's hard to get started on something before, and it's hard to
Right.
pick up on something afterwards. And I just thought, let's just do it in the morning, and you know, salvage the afternoon and stuff like that. So anyway, that was sort of the progression of it. And then I started doing some radio and stuff, and so the whole idea of this is to let people know that, hey, there's options you can do in estate planning.
Sure.
When you hear, estate planning, you're just not sure what that really means. The first thing that comes to mind is writing a will, and that's of course part of it.
Yeah.
But there's so many other things that you can do in estate planning that you just haven't thought about. So when you come to a seminar, I talk about things, and you often heard me say to be open-minded if you come, because if you come and you hear things that you've never heard before, don't be resistant to that.
Yeah.
Just let it in. I had a father-in-law or stepfather-in-law, or whatever that would be called,
Yeah.
who constantly would say things like, "Well, I never heard of that, so I don't see how that can be." And it's like, just that's a closed mind. Well, if I heard it, it can't be, right?
Yeah.
Don't have that closed mind. Just hear it. And again, I don't charge anything for it. You
Sure.
can come. I am very free and very non-pressure. There's no obligation whatsoever. I'm not going to lock the door and ask you to sign something. I'm not going to, and I often say, I'm not here at this seminar to talk you into anything or to talk you out of anything. I'm going to tell you what's available, and if you think one of the other options is a good fit for your family, then let's schedule an appointment. We'll talk more about it. If it's not, have another one of Miss Tammy's famous muffins, and we'll still be friends. It's okay.
Yeah.
It's a good fit for most people, but I guess it's not a fit for everybody. And if you don't want to do it, I'm not going to get mad at you. I'm not. And here's why. You've often heard me talk about this too. When people do something, the best way you can do it is with an informed decision. An informed decision doesn't mean just decide something. It means you've looked into the different options, you've weighed them, and you say, this is a good fit for me. Or none of these really hit the nail on the head for me. I'm not going to do anything. But you have to know what the options are out there before it's so much easier to
Sure.
make a decision if you know the things you're picking from. But for certain things out there that you don't even know you could pick them, it makes it hard, makes you procrastinate because you don't feel like you're. I get that all the time. People say, I've been wanting to do a will for years. I just don't know what to do. And as soon as they come to my seminar and we talk about doing a trust, I think, that's it. That's what I want to do.
Yeah.
And so, they lean towards that, but they lean toward it because they hear about it. Or they hear me talking about it and they want to know more. And so that's kind of how the whole thing evolved.
Yeah. I'll have to admit, that when we first began having you here and I began to listen to you, I had no idea that this was this kind of an option.
Yeah, I thought that when I first started thinking of estate planning. I remember thinking to myself, or I said to my wife, I thought, I think that would bore an idiot. That was a phrase I had an uncle who used to say. and I thought, it didn't sound very exciting. It didn't sound very glamorous. And anyway, but the more I looked into it, and that was because I didn't know all the things that you could do as a estate planner. What I mean?
Yeah.
And so I started getting into it. I think it's terribly fascinating. Everybody's different. Every family's different.
Sure.
The problems we get to solve are really kind of cool.
Yeah.
So, yeah, it's really
Absolutely.
kind of fun. So.
Absolutely. Well, I guess we can entertain a call if you'd like.
Gosh, I hadn't even started the subject yet.
I don't think it'll matter. Good morning. How are you?
Yes, I wanted to throw out something that I think is important. I was, because I don't know the answer, and I know Mr. Pierchoski does, I was listening to these high levels. Can you hear me okay?
Yes.
They were from other countries, and I might suspect is maybe they were even billionaires because, but one of the things that came out of the discussion, and I'm going to throw this out, is, and I'm sure they had trust because they were talking about things like that, was the big issue is control. And then they discussed about how the younger people, and they got into some pretty negative things about their kids and their grandkids and stuff and how they set things up differently. But one had to do with, well, if they don't like what you do, then it's control. In other words, they want the money, but they don't want you telling them what to do with the money and where to live and things like that. Okay, well, they can find a lawyer and work around that. Okay, so my question, I think a lot of people, and it's even based on scripture in the Bible days, it's better, the Bible Belt, it's better not to make a vow than to make one. Also, the issues it causes in families, and then extended things, how you can't predict the future. Number one, how complicated is it is, let's say somebody does a trust, to change it or to dissolve it if something happens, unpredictable, totally unpredictable, and there's agreement. But then if they die and their spouse has things in there for them to dissolve it, and how complicated, and can that be done? Another thing is non-disclosing. You know, they're using this a lot with businesses and government now, where you don't have to tell. And I understand with very wealthy people and people just in general that they actually have this in divorce papers and things, and I was wondering if there are things in trust that the party could not know about. I know that's complicated, but I just wanted to throw that, because I think those are questions people have reservations about.
Okay, all right, thank you. She's gone.
Okay.
Dale, I guess you understood most of that.
Well, wasn't sure where it was going until we got to the end, but I jotted it down as we were talking. Let me just address them in order. Well, let me start with the last one first. It's talking about disclosure of information. Can you do trust, like between people, especially husband and wife, where there's terminology or terms and conditions in a trust that are not disclosed to the other person? Okay. Now, all I can say about that is I'm sure that's possible to do. I don't. Usually when we have husband and wife, almost 100% of the time, they do a joint trust.
Yeah.
As a matter of fact, they know everything that's in there.
Sure.
Even if it's language in there, like if they worry about one of them passing away and getting a remarried.
Yeah.
Sometimes we'll say, before you can get remarried, you have to enter into a prenuptial. And we want to do that so that we protect that property to go
Sure.
to the children it was originally intended to go to. And so they'll have language in that, but both people know about it. As a matter of fact, at the end of the documents, I have a boilerplate spousal waiver of conflict. In other words, when you represent a husband and wife, I can only do so if we have what's called full disclosure. So to give you an example, if you and Teresa were getting divorced,
Yes.
I couldn't represent both of you because anything I did for one would be adversarial to the other.
Yes.
And but I can represent a husband and wife, and everything's by full disclosure. So a lot of times I'll say, you know, husband, everything I've done for you in this estate planning, wife, you know about because we all did it together, and we all signed off on everything, vice
Yes.
versa. So I guess I'm sure there's probably some trusts or documentation like she was talking about where things are not disclosed to the parties. That seems to run afoul of a fundamental law, but it's possible, but none of anything like that do I do. You know, we do estate planning for families. There's no need to have something hidden, and so we don't. But then now she talked about how difficult it is or how complicated it would be to change a trust or to terminate a trust. And then she even went on to say that after maybe one of the spouses passed away and you have the surviving spouse, if circumstances changes and they wanted to change the trust or terminate the trust, right?
Okay.
So changing a trust you can do, okay? And a lot of people, you can even change the irrevocable trust we do, which surprises people because I tell them, you know, irrevocable doesn't mean unchangeable.
Yeah.
You can modify it. You can always modify where the property goes at death. You know, like, so let's say you're leaving it 4 kids and for some reason one of the children is struggling all the time and another one marries into money and you think, you know what, I'm gonna make it a little lopsided to help the one out that needs the help and
Right.
not give the one that doesn't need the help as much help. You know that sort of thing. And you can modify that sort of thing. But you can, in the revocable trust, revocable living trust, you can change as much as you want, whenever you want, for any reason or no reason at all. You just have to be alive to do it. Okay. At death, there's no more changes. Now it becomes cast in concrete, and it has to, everybody that survives you is stuck with the wording at that point in time. So changing it's not a problem. It's just a little different process. With a revocable living trust, we just do an amendment. Very simple thing to do. In my asset protection trust, they're a little tighter, and there's the methodology for changing an asset protection trust is you exercise something called the limited power of appointment, and that is how you. But the end result is a change. Okay. Now to terminate a trust, you can terminate any trust. And the revocable living trust is easy. You can just decide to scrap it. All that's really required is you distribute all the property that's in the trust out of the trust. Now when you have a trust that has no property in it, it terminates under a frustration of purpose, and we just give notice to everybody that it's terminating, interested parties that it's terminating, and it's a done deal. It's a pretty simple thing. Now the irrevocable trust, we're talking about revoking the trust, right?
Sure.
And that's really where it gets its name. You say, why is it called a revocable living trust? Well, we talked about the living before. That's because it's done during your lifetime.
Okay.
You don't do it after death like a testamentary instrument, like a last will and testament, right?
Okay.
But you do it during life. But the revocable part, it's revocable not because you want to revoke it, but you can make as many changes to it as you want, all the way up to completely revoking it, which would be like a 100% change, right?
Okay.
That's where it gets its name. So no problem changing a revocable living trust in any way, shape, or form. However, when you get the asset protection trust, I'm going to say something that always shocks people. and that is you can revoke an irrevocable trust.
Okay.
And, you know, people say, well, that's a bunch of legal double talk, right?
It sounds like it.
Now, to me, the word irrevocable is an unfortunate name. I'm not really sure how it got that name, but I mean, here's the straight scoop. You can revoke an irrevocable trust. Our Uniform Trust Code is extremely clear on how to do it. There's the procedure for doing it. There's two ways to identify the difference. I heard some folks on the radio, I wasn't this station, but they were talking.
Sure.
They came up, what's the difference between a revocable trust and irrevocable trust? And they said, well, I guess one you can revoke and one you can't. That is not the answer, okay? The answer is, there's two things that define what an irrevocable trust is. An irrevocable trust, you, the maker of the trust, cannot be the beneficiary.
Okay.
Now that's what gives us the creditor protection we want to get when we're trying to protect property from long-term care in the future and stuff like that, or any creditor. And the other thing is, you, the maker of the trust, cannot revoke it unilaterally. In other words, you have to have the beneficiaries agree with you.
Okay.
So if something happens, circumstances change, I mean, it's like, okay, we got this trust, but we need to scrap it for some, you know, we need to get the property out of it for health reasons or something like
Sure.
that, you know. And you can terminate the trust. You can revoke it. And we do that sometimes. I only ever done it once, but if I often say one of the goals of our asset protection trust is to put property into it and stay the heck out of the nursing home for 5 years, right?
Sure.
And if you get several years into it, like 3 years or something like that, and you end up in a nursing home, then we kind of want to stay with the trust and just kind of get to 5 years, right?
Yeah.
But if you do this trust and like 6 months into it, very early, 6 months to a year into it, everything goes to heck and back in a handbasket and you end up in care. Probably, if we do the numbers and run the numbers, it probably will not support staying with the trust for another 4 or 4.5 years to get to 5 years, okay? If that's the case, what we do is we just back out of the trust, meaning we just revoke it, undo what we did, and we just flip the switch and go into this crisis planning that you hear me talk about from time to time. Because now, it's more of a crisis planning case. Crisis meaning, of course, you come to me and say, or Teresa comes to me and said, what can I do, Stan? Jeff had to go into long-term care and we need to protect our stuff. And
Right.
Crisis means somebody's there already, or very, very close to it. The pre-planning of the trust is, we're not there yet. We're going to put a property in trust, we're going to divest and wait this 5 year period. Because
Yes.
I can't get rid of the 5 year period, I wish I could, but I can't. And so, you know, it's not very complicated at all to change it. I actually, on the revocable living trust, I actually show the people how to make their own changes. Now, I tell them, if you want me to make them, I'm glad to do it, but just to show you, right, example, how easy it is to change, we can do that.
Wow. Okay.
And you know, there's some people, you know, I helped with a lawsuit out of California, because I had somebody that moved here from California, and I was representing them, and they had a trust that was out in California, and they just decided, they decided to take somebody out of it, disinherit them. And being a revocable trust, you can do that. And they did, and the person got mad and sued them,
Yeah.
which was a frivolous lawsuit, but, you know, and there's some case law where the upper courts have said, on a revocable living trust, you are the beneficiary at the whim of the trust maker.
Yeah.
He can put you in and leave you 100%. Next day he can take you out and leave you 0%. He changes every day of the week because you have no entitlement to an inheritance from somebody if they don't want to give it to you.
Yeah.
In legal terms, they said that, but they did use the words, you are a beneficiary at the whim of the trustor, which is the trust maker.
Okay.
Asset protection trusts are a little different. When you name beneficiaries, you're also locking down you know, to terminate the thing, to revoke it. You and the beneficiaries need to be on board, okay? And the trustee, all three parties have to have no objection to.
Okay.
And but if you want to make a change to an asset protection trust, you don't need the beneficiary's permission. You can still make the change. You just need their permission for a revocation of it.
Interesting.
Yeah,
Okay.
well, I mean, there's a lot to it.
There's a lot to it.
But I mean, the answer to the question is, the revocable living trust is super non-complicated to change. The asset protection trust, just a little more to do because it's something we exercise. We exercise that limited power of appointment, and that's a very important thing in those kind of trusts that makes them creditor protection.
So the creator of the trust can change the trust.
Yep, he's the only one that can change the
The
trust.
only ones can change the trust.
If you name somebody a trustee, they cannot modify the trust.
Okay. So if let's say that Teresa and I have created these trusts, and after our passing, we're both gone to be with the Lord.
Okay.
Okay. And the trust still exists.
At that moment of passing, that trust becomes irrevocable, and nothing can be
And
changed.
nothing can be changed.
Which means, and then you have a successor trustee, right? We sometimes call it the after-death trustee.
Okay.
They cannot substitute their judgment for you.
That was the question I had, is once the creators of the trust have passed and gone, then the trust is.
The trustee is bound to distribute the property the way the trust
can't
says to
change the
do
trust.
so at the death. In there it'll say at the second death of us.
Part of what I thought she was asking is the heirs or the folks could change the trust.
Okay, well, maybe it was, I didn't catch that
Yeah.
part, but no, the answer is absolutely not.
I didn't think so.
Let's give an example of that. It says in the trust, you put in there, okay, here's how my stuff goes. This goes to my 3 kids, and this goes to the church, and this goes somewhere
Right.
else, okay? Now, at death, that becomes irrevocable. I mean, no modifications can be made. And even if the trustee doesn't like what you're doing, he is bound. It's a fiduciary duty to the best interest of the trust.
Yeah.
And the best interests of the trust are to do what the trustor said to do in the language of the trust.
Right.
And now that the trustors are gone, they're not there to argue their position. So the courts have said the intent of the trustor is paramount.
Yeah.
So we're going to stick to that, absent some reason not to.
But in the movies,
Yeah, okay.
you see these people challenging the trust or challenging the will.
We can challenge it.
You know.
You just won't be successful.
You just won't. It just ain't gonna work.
Well,
Okay.
it's a tough road to hoe. Oh, there's some challenge. I don't know if we'll get into challenges today, but there's some challenges that can be made, and there's ways to avoid those. There's language that can avoid those. Here's a good example. Had a guy. He was the successor trustee, and his mom lived to be 104 years old, and he was like 80. Okay.
Yeah.
And he was a successor trustee, and he had a sister.
Yeah.
And I remember sitting in my office in Pulaski, and this is what he said to me. He said, and his mom had, over the years, her and her husband had developed a fair amount of wealth. Okay?
Yeah.
And I remember sitting there at my big conference table, he's sitting there, he says, I know, my sister lives up in Columbia or Brentwood or something like that. He said, she hadn't called mom in 10 years. She didn't even send her a Christmas card in 10 years. I don't think she deserves this $200,000 that mom left her. And my response to him, I said, let me tell you, in a nutshell, I said, well, I'll tell you what, here's what you need to do. You have fiduciary duty to do what mom wanted. It doesn't matter what you like or don't like. I said, so here's my advice. Bite your tongue, hate every second of it, but write the check and mail it to your sister. I said, because if you don't, she will sue you for breach of fiduciary duty. And don't ask me to represent you on that because I can't win it.
Yeah.
She will be right. That's exactly what you're doing. You have to do what the trust says. You don't have discretion.
Yeah.
It's not like, you can't, it's called substituting your judgment for theirs.
Yeah.
You just say, well, I don't like what they did, so I'm going to change it. I mean, if that exists, there's no point in doing the trust in the first place.
There you go.
Because
Yeah, right.
it's supposed to work at death, and you're not here to argue your position. Your position
Yeah.
is that document.
Yeah.
And it's one of the only places in law where I found in the notes where the legislature said the intent of the trustor is paramount, and that's what we will do.
Sure.
Absent some illegal purpose, you know what I mean? If you say, I leave my farm to my son and I want him to continue the marijuana farm I'm growing here, or something, and it's common sense stuff.
Right,
But,
right.
a good example of that, and I think I've talked about this before, but there was a case out of a neighboring state, I think it was Mississippi, something like that. But and it's a good example of the court saying, we're going to follow the trustor's intent.
Yeah.
Because that's what the law is for trust.
Right.
And so this one lady, she had a son and a daughter. And in her trust, she had language, and I'll give you the Reader's Digest version, but the language said I leave half to each, right?
Right.
Typical. And she said, half that goes to my daughter, I just leave to her outright. No, she just gets it.
Yes.
And of course, without just reading between the lines, if she didn't have any problems with her, thought she could handle the money, no big deal. But she said, but to my son, if he is married to the woman he's married to at the time of this writing, at my death,
Yes.
his half goes into trust that the sister's trustee over, and then she listed a bunch of terms and conditions that he couldn't have it for, and stuff like that.
Right.
But if he's not married to that person, he gets it outright when free of trust and stuff, just like the sister did. Now, if you read between the lines, mom was not too happy about her daughter-in-law, right?
Yeah.
I mean, she didn't say it, but she was not too crazy about the daughter-in-law. And so the son was married to the woman when she passed away, and he said, this is an unfair violation of my right to own property and stuff like that. So he takes it to court, and it comes to the appellate courts, and the appellate courts said just that. They actually used the language that said, we are here that the legislature has deemed that the intent of the maker of the trust is paramount.
Yeah.
And that's what we're going to follow. Said she clearly made her intent clear that the money went to the daughter, no problem. but she made her intent clear that it was conditional how it went to the son. Unfortunately for the son, the condition was he goes to trust over his sister, and that's what we're going to hold, because that's what she wanted to do.
Yeah.
And it had nothing to do with him, had nothing to do with his rights. It has everything to do with you, and it backs up to this. It's you, Jeff. It's your stuff. It goes
Right.
wherever you want it to go.
Right.
People say, well, I have to leave it equally to my kids. And most people do. You don't have to leave it equal to your kids. Equals what you think it is, right?
Yeah.
If it's like what I said earlier. Suppose you have 3 kids, and one of them just good kid, good person, struggles, always holding down 2 jobs, never barely make ends meet, and have $1.50 left over. Making it, but just not luxury. And you have somebody else that say was either very successful or married and a lot of money.
Well.
And you suppose you leave a little more to the one that's having trouble, but less to the one that has plenty. Is that unequal?
Yeah.
Not in the eye of the person doing it.
Well.
It's for a reason. You're not there's no entitlement to inheritance. You're not entitled to anything. It's all gravy. It's a windfall. If you get anything from your parents in inheritance, they just take it, be happy, and don't complain about it.
Absolutely.
So there's no entitlement. You have no right to enforce.
Yeah.
The only time you can challenge what you get is if there's been some kind of undue influence,
Right.
Or if you just are silent on an heir and don't mention them at all, or something like that. There are certain ways to challenge stuff, but there's easy ways to defeat those challenges in the language of the trust if you know what you're doing.
Yeah.
So it's your stuff. You can do whatever you want. I often say you cannot disinherit a spouse, but you can disinherit your children.
We use the word control, I guess.
Oh, okay.
You're controlling the assets after your death.
That's right. With his trustees, and they're controlling it according to the terms and conditions of the trust.
Yes.
They're doing what the trust says to do.
Yeah. Yeah.
So if it says, you know what, I don't want my kids fighting over the house, so my trustee shall sell it and divide the proceeds.
Yeah.
Now, the word shall, in law, there's what we call should, shall, and may.
Yeah.
There's no discretion in shall. So that
I like the word shall.
the trustee has to sell it and divide the proceeds. Now, that doesn't mean what if one of the kids really wants it? Well, what I usually do is say the trustee will sell the property and divide the proceeds. However, if any of the heirs want the property, the trustee will allow them to buy the other ones out first before going to like an open market and selling and stuff like that. But if it's shall, then that's what they have to do. I mean, if somebody wants it now, they can just bid on it, right? So when the words have the meaning that you have to interpret.
Yes.
And we try not to make anything that's ambiguous or nebulous where you don't understand what it means.
It's interesting you said that because we do a word of the day here before you come in. I always do a word of the day and try to learn new words. Sometimes they're new to me, sometimes they're not. As a practicing attorney and somebody who practices law, you have to be very well read. You read a lot.
I do.
You read a lot. Well, my question to you is, when you run across a word, maybe that you haven't encountered, do you stop and look that word up, or you just try to develop a definition based on the context?
Maybe a little both. Mostly I look it up, especially if it's in a legal context.
Yeah.
Because when I read one up, I think I don't know what you're talking about.
Yeah.
There was my assistant brought me something just yesterday or the day before, and it was one of the statutes. She printed out and highlighted something, and brought it to me. And I read the first sentence, and I can't. It escapes me what it was. But I read the very first sentence, and I said, okay. It was something in a conservatorship that has to deal with a property management plan.
Yes.
And it finally said, within 60 days you'll file a property management plan.
Yeah.
And I said, okay. What's the management plan? Go find the statute that says what that is.
Yeah.
Because there's one out there. There got to be, especially in law, that sort of thing.
Yeah.
And so I'm saying, okay, I understand the words, property management plan, but what is that? What are we talking about? With Excel spreadsheet, some kind of ledger thing. It's usually easy to solve, but yeah, most of the time I do. But there are times when I don't.
Yeah. Yeah. I read, but it's laborious to me.
Yeah, well.
And then I run across a word, and I'm like, gosh, I don't know what that, I have no idea what that word
It's easy
actually
just
means.
to type it in. If you type in just the word, hit return, you get the definition.
Yeah, it works. Yeah, it works. So, anyway.
But it's sometimes awkward. You're talking to somebody and they're using a word, and the way they're using it is completely wrong.
Oh.
I'll tell you one of my pet peeves is
I've been guilty of that plenty of times myself. So.
one of my pet peeves is the word irregardless.
Irregardless.
There is no such word. There is no, it's regardless.
Regard-
There's no such word as irregardless.
Well, we use that word a lot.
Well, you regardless or not.
Yeah, but I mean, I've used
Well,
irregardless.
I'm not poking holes at you, I'm just telling you. Now, when somebody uses it, I don't correct them or anything, but maybe I should, I don't know, I don't want to be petty, but there is no such word.
Yes.
Irregardless. It's always regardless. I mean,
Just regardless. I'll keep that in mind.
well, if it's irregardless, then it's not regardless at all.
That's true.
No, you know, let me tell you this, I'm getting off track, but this along these lines. I come up with this thought process, you know, when you're in when I used to do court, and I put a witness up there, you know, and the question was once asked, do you understand the English language, you know, something like that.
Yeah.
It's condescending remark that
Yeah.
made somebody. I got thinking about that, and I thought, so I did a little research. Turns out, and I'm spitballing the numbers by memory, but there's something like 525,000 words in the English language.
525,000.
That's
Wow.
right.
Okay.
Now, the average person's vocabulary is anywhere from about 25,000 to 50,000.
Yeah.
Average vocabulary for average people.
Yeah.
That's a lot of words, right?
That's a lot of words.
So if somebody would ask me, do you understand the English language? I'd say, you know what? I understand about 10% of the language. So anybody who understands 10% of the subject, I say, doesn't understand it very well.
Yeah.
So no, I don't understand the English language. And I consider myself educated. I do not know 525,000 English words. You pick away at one every Friday.
Yes, I try to get one every day.
Is Joe here every morning?
We did one this morning, yes.
I know, but I see her every
No,
day.
only on
I was
Fridays.
saying, you do the word of the day. you
Yes,
know.
yeah.
And, you know, I'd say
Yeah.
probably half the time I know the word when you come up with it.
Yes.
But half the time I don't, because it's definitely
Yeah.
those unique words, which is fun, you know.
Yeah, this was the word today.
Oh my gosh,
Effulgence.
don't know it.
Well, I didn't either.
But I'd be interested to know.
But it's radiant, splendor, or brilliance.
Ah,
So there you go.
seems like we should know that since
We should know.
since we've got it.
Yeah, since we possess a little bit of that.
We also possess the word
But I really like the word shall. It's a definite.
should, shall, and may.
I like the word shall.
Should is suggestive. May is permission.
You know, with the
Shall is no discretion.
with the announcement of Christ, He shall save His people from their sins. It was that's a shall.
That's right.
Amen.
We don't want to get into law school 101 here, but I mean, but you know, when you deal with an attorney, I mean, that's what they're supposed to do.
Yeah.
But you know, there's also our Supreme Court has says when you're doing what we call statutory construction,
Yes.
you're to use the regular meaning that the words are designed to mean.
Yes.
So if you make it with a bunch of legalese, you can muck up the definition. You know? And Thurgood Marshall was the first black man on the Supreme Court.
Yes.
He had a talk one time where he talked about the word no, and it was
Oh,
fascinating.
my.
It was fascinating. He said no's in the Constitution. Okay, he said no's are very easy. You know, I think he was talking about something in Article 1, Section 10, where it says Congress will do no. Let's say pass no law that's ex post facto. That's one of the things in Article 1, Section 10.
Okay.
Ex post facto means reach back in time. You know what I
Yes.
mean? Like in other words, let's say you drove on the left side of the road and not a crime, but a year later they say, okay, driving on the left side of the road is a crime, and Jeff did it a year ago, so we're going to prosecute.
Yes.
You can't reach back in time. You make that law go from now forward, right?
Right.
And he had his dissertation on the word no, and he said no is a very easy word. It means no. No doesn't mean sometimes. It doesn't mean maybe. It doesn't mean, well, if I have a really, really, really good reason for doing it, he says no means no. He said,
Yeah.
don't overthink the word no. And so I think it was about an ex post facto law. And he said it is, and you can't have it. And he said,
Yeah.
but it's really needed to do this to correct a tremendous injustice or something. I said,
Yes.
sorry, the Constitution says no. No means no. There's no. It's like shall. I mean, it's absolute. It
Yeah.
means that, and that's all there is to it.
If they don't have those meanings, then we're just we're at the whim of anybody's idea.
That's right. Let me give you an example. We're kind of off on a.
We're off on a rabbit trail. It's okay.
We're going down a rabbit hole. You know, not too long ago, Virginia drew their districting maps. And
Yes.
it was like originally it was like 6 people got Democratic nomination, or 1 and 5
Yeah.
people. There's 11, 5 got, and they drew it up and now it was 10 to 1. right?
Yeah.
It was what, and it went to the Virginia Supreme Court, and they struck it down for being, it discriminated based, you drew the lines based on race, and they said you can't do that.
Yes.
So they struck it down.
I remember
right?
this.
And then right after they did that, there's all this think about, they said some law professor came up with a great idea. He said, what we're gonna do is change the retirement age of the Supreme Court justices on the Virginia Supreme Court. And he said they're thinking about the legislature, the state legislature is going to change the retirement age. The retirement age was like 54, which happened to be 2 years younger, 2 years earlier than the youngest person on the court.
Yeah.
You know, when you get ported to the Supreme Court, you're usually there for life, or at least the federal.
That's, yeah,
the
on federal, for sure.
So this was they said, we're going to do that so we can get rid of everybody. Well,
Yeah.
there's a problem with that. You can't have an ex post facto law. Now, even the Virginia Constitution can't say you have one because the federal Constitution prevails as the minimum level of protection. You can have more protection in your state constitution, but not less.
Yeah.
And so, the Fed's going to. So if they do that, that's an ex post facto law because you have a sitting justice, and I think the retirement age that they do have a retirement age in there. And I think it's like 75 or 80 or something like that. Where you do have to retire by then. Nothing wrong with that law.
Yeah.
But now if you say, okay, the youngest person on the court is 60, so we're going to make the mandatory retirement age 55.
Yeah.
So as soon as we pass the law, all of them got to leave, and we can cherry pick and put in the ones we want. I.e., we'll put in the ones that will say this redistricting
Sure.
is okay, right?
Yeah, exactly.
Now they got a real problem, and I know the Supreme Court in Virginia are probably laughing at those fools because they say, yeah, we'll be the ones interpreting the law you write,
Right.
and it's ex post facto. You're going to make a law that's effective in time before you make the law.
Yeah.
And now it doesn't work that way.
It won't
now,
work.
if you don't get me wrong, you could do a law that says the new retirement age is 55, and so if anybody that comes in, they have to retire. at
But it would
55.
apply from that point forward.
But you can't go backwards for the people that are there.
Yeah.
I mean, people sometimes use the word that's grandfather. It's not. It's a good enough term, but the point is you can't reach backward in time and change things.
Right.
And that because King George did it all the time. That's why it worked its way into the Constitution. They used to do that kind of stuff. They didn't like what the colonists were doing, so they passed a law against it and prosecute everybody that ever did that.
Yeah.
Which is like, are you kidding me? Because we grew up in an era where you can't do that.
Right.
But there was a time when they did that, and
Yeah.
it was patently unfair. I mean, you can do anything if you do that, and they did. So anyway,
Yeah.
if you have the power to enforce it, then you can just do whatever the heck you want. The king had the army, the overwhelming,
Yeah.
biggest nation in the world, biggest army in the world at the time. So stuff like that. Romans did it. But anyway, and I think he was talking about that where in Article 1, Section 10, it says no ex post facto law, which is
Sure.
Latin for relate back in time. And
That's a good law.
And he said, you cannot. He said, suppose there was a reason like, oh man, if we do this, it's going to just correct so many injustices. And it's going to be a very good thing for us to do. And it's like, no means no. You can't do it. Fix it some other way.
Yeah. Yeah. Very good.
Well, and you think about it, I can't think of any circumstance where it might be a good idea.
I've been in recent years, I guess, in recent months and years, not as a young man I ever paid it any attention, but the Supreme Court cases are so interesting to follow.
Yep.
And especially right now, it's been amazing.
A couple of them I don't agree with them.
Yeah, a couple of them I'm like, what are you guys doing? Anyway. And do you know, and you probably do, that you do not have to be a lawyer to serve on the Supreme Court?
I know that.
That means that I could actually
There's an age requirement and a residency requirement.
that means that I could actually make it to the Supreme Court somehow.
You don't have to be a lawyer to be the president. I mean,
Yeah.
you don't have to be a lawyer to be in Congress.
No.
All of them are, practically, but you don't have to be.
Yep. So anyway, I'm going to nominate myself
All right.
because I didn't like some of the decisions, and I would make a better one.
One of the cases that they recently decided was the one about temporary immigration status.
Yeah.
All those people that came over from,
Yes.
where'd they come over from? I forget.
Yeah.
Anyway, that hinged on the meaning of the words.
Yeah.
Because they said into the United States, not
Yeah.
standing at the border.
Yeah.
It only applied if you came into the, so they could stop people at the border and turn them away.
Yeah.
But once they came in status, and the argument was, well, they're here, they came all the way over here, they're seeking asylum, they're standing at the border wanting in, that's good enough. And they said, no, it's not good enough.
Yeah.
And they even said, Congress wrote this law, that's what it means. And,
Yeah.
our job is to interpret the law, and we're interpreting it. Congress has the power to change it if they want to.
Yeah.
But that's what they said. They said we're not talking about Congress's ability to change stuff. We're talking about what they did.
Well, unbelievably enough, we're down to about 2 minutes.
Wow.
Can you believe that?
Well, we better wrap it up.
You need, well, I want to tell folks, make sure,
Let's just stay another hour.
I want to make sure that they know about your seminar coming up
Right,
on
right.
the 25th.
July 25th, 10 o'clock in the morning, here at the WLX radio station. We call it Will's Trust and the Nursing Home. If you don't know the address of this place, it's 1212 North Locust Avenue in Lawrenceburg, if you're listening to me from afar.
Yes.
We start right at about 10 o'clock as best we can.
Yep.
And we'll have some refreshments there and stuff like that. So it's worth coming to.
Not hard to find at all.
No. Just don't come in the front door where the radio station is. It'll probably be locked anyway. But there's a double door toward the back of the parking lot, and you'll see the cars. And that's
Under the big tower.
right where the big tower hits the road. There's a set of double doors right there, and that's the place.
Under the big tower. That's July 25th, starting at 10 a.m. here at the WLX Country Cafe. And of course, if they need to reach you before then,
Yeah, call my office at Pierchoski Estate Law at 931-363-7222, or you can go to my website, estateplanstand.com.
Estate Plan Stan as always, and got a lovely new office over there in Pulaski, Tennessee.
We've been there 6 months now.
Been there 6 months. Wow, in a really nice place.
Yeah.
I like your new office, and a good place to visit too. There's a couple good places to eat over there if you want to do that.
That's right. If you can't find something, I'll make you something. We have a kitchen now, so.
That's right. All right. And of course, you've been listening here to Bulletproof Estate Planning with Stan Pierchoski, Pierchoski Estate Law. Helped me out on a couple of occasions already in our family, and we appreciate that.
And we'll be back next Friday,
Yep.
8 o'clock.
That's right.
Bulletproof Estate Planning.
That's right. Well, we still got a few seconds left here
Okay.
before it actually hits on things, but anyway, it's always good to have you. You'll be back next Friday, good Lord willing.
I will.
All right. All right. Well, we'll see you next time. I'm going to hit the buttons up here.
Timing's always an issue in radio. So,
It
but we
is.
will see you next week.
That's right. All right. See you
Always a
next-
pleasure, Jeff.
See you next time.
Bye.
This is WDXE.
That was fun. I didn't get my call, so.
237 FD 95.3, Lawrenceburg.
All right, well, I gotta run over to the registrar's office before I go back and record the deed.
Thank you.